Hi, Ron LeGrand here. Before we get started with the podcast, I thought you might want to know that I recently recorded a 90-minute online training about how we make so much money today in the terms business. That's on pretty houses in pretty neighborhoods, not the junk houses that we have to go rehab or wholesale. I go through step by step on exactly what I and thousands of my students are doing right now to make the fastest and the easiest money in real estate without using your money or credit. If you're interested in doing just that, go to thementorpodcast.com/free training. See you there.
Welcome to the Mentor Podcast, where the most highly motivated entrepreneurs come to get their weekly dose of financial stability with host Ron LeGrand, as well as other nationally recognized thought leaders who will teach you how to get, grow, and protect your wealth.
Hello, everybody. This is Ron LeGrand and another issue of the Mentor Podcast. And today's subject is land trust. I get quite a million questions on it everywhere I go, so I thought I'd just take the time today and knock out all the questions that I've heard over the years. And maybe by the end of this thing, you'll have a clear understanding of what land trusts are all about, why I am such an advocate of them, and why they're used all over the country. So starting, first of all, a land trust is a very simple entity. It totally gets confused and misconstrued by attorneys and others, but it's just not that complicated. It's nothing more than an entity to hold title to a property. It consists of two parts. There's a deed called a warranty deed to trustee, or in California, a grant deed to trustee. That's the deed that puts the property into a trust. So either the seller is deeding the property to the trust, or you're deeding your own property to the trust. It requires that deed. And then there's a trust agreement. A trust agreement is a multi-page document with at least 5 or 6 blanks in it. Those blanks will be filled out by you. And then that trust agreement will be filed in your filing cabinet at home. You're the only one to see that trust agreement, and that is the only place the beneficial interest is named. The beneficial interest owns the trust. The trust owns the property. If you're the beneficiary, you will own personal property called a trust. The trust will own real property called a house. So it's very simple. And in fact, you won't even be filling out the deed unless you're putting your property into a trust, which you can easily do. The deed itself doesn't have more than 5 or 6 blanks on it to fill out. And so once you've done that and recorded that deed, then your property's in a trust, whether you filled out the trust agreement or not. People always ask me, well, how do you form a trust? Well, you fill out the deed and you record it, and the trust is formed. Now you go home and fill out the trust agreement, which explains who does what in the trust. And again, it goes in your filing cabinet. Now, there is always a question, do I need an attorney? Well, if you get the trust agreement out, if you get the warranty deed out, which you can get on our website, ronlegrand.com, or on our Gold Club site, if you happen to be a Gold Club member. By the way, if you're not a Gold Club member, you're missing the biggest bargain in real estate today. So you might want to think about going to ronsgoldclub.com and signing up, because it's only $59 a month. And there you will find all of our forms and agreements, including the land trust, and tons of lessons on them. And in fact, there's 1 or 2 on there much longer than the one I'm doing here today on this podcast. So it would behoove you to take the time to learn about land trust, because I promise you, if you're going to be buying real estate, you're going to be using them. And if you're not going to be using them, you're about to hear the cost of using LLCs, like most attorneys will recommend that you do. So go to ronsgoldclub.com and check all that out if you're not a member. And if you go to the resource section, you can go down to the forms and agreement section, and there you'll find a search box, and you can find any documents you want. You're looking for a warranty deed to trustee, and you're looking for declaration and agreement of trust, I believe that it's called. When you fill out those 2 documents, you have got a trust. But again, the deed must be recorded before anything happens. If you don't record the deed, you don't have a trust yet. Do you need it to be recorded? You need the deed to be recorded. You don't need the trust. You never record the trust. You only record the deed. Remember, the trust agreement goes in your filing cabinet at home, never to be heard from again until you get ready to sell the property. Now, your title company or attorney will probably want a copy of that trust when you get ready to sell that property. I'm guessing just so they can prove that the beneficial interest has given the trustee the power to sign the deed. As beneficiary, you will never sign anything except that trust agreement. The trustee from that day forward signs anything that needs to be signed, which is usually just the deed, signs it as trustee. So if you are taking title in a trust and you get ready to sell, that trustee will sign as president, or, well, if it's an LLC as trustee, then the manager of that LLC will sign as president of that LLC. So it'll go ABC LLC, comma, as trustee, Joe Blow, comma, manager. And that's how the deed will be signed. Nobody's liable. There's no liability involved in a land trust. So yes, the deed has to be recorded, but there's really no reason not to do this, which I'll show you all the reasons to do it. But then people always ask me, well, is there a reason not to do it? And the answer is no. Okay, there's only really one downside of land trust, and that is public ignorance. And as far as I'm concerned, that's an upside, because the less people know about it, the less they're going to try to come challenge it. And I don't care if they know about it. It's not our job to teach other people about this land trust, and that includes attorneys. And you don't need an attorney's permission to use a land trust either. When that deed is recorded, it is in a land trust. We don't have to ask anybody's permission. And by the way, can the bank call the loan due? Absolutely not. There's a federal law called Garn-St. Germain Federal Depository Institution Act of 1982, which prohibits the bank from calling a loan due because you put your property into a trust. That's Garn-St. Germain. So look it up for yourself and read it. It's also the same act that established the due on sale clause in loans, and also had a bunch of exclusions. And one of those exclusions was putting your property into a land trust. You don't have to pay transfer tax either. When you put your house into a land trust, like here in Florida, we've got to pay $7 plus recording costs to put a house into a land trust. Now, that doesn't eliminate transfer tax if I'm buying it. But on the other hand, that's a whole nother subject, because if I'm buying the property from the seller, transfer tax will be paid, usually by the seller, unless you're buying the property with nothing down and you're paying all the closing costs. But you will be paying transfer tax. There's a way to get around that, but I'm not gonna discuss that on this issue, because I'm not, I can't promise you 100% that it's going to work where you live, or it's not going to get you into more trouble than it's worth. But just remember, when you take title to a land trust, every seller has the right to put a property into a trust without paying transfer tax. Now, what happens to that trust after that? Well, I could say if that trust transfers to you, then there is no transfer tax. But that would require you talking to a good real estate attorney to verify that where you live. There are really 4 good reasons to have your property into a land trust. The first is privacy. And in fact, as I just said, when you put your property into a land trust, nobody knows that you own the land trust. Nowhere on public record does the beneficial interest show. So you have total privacy. Total privacy means nobody knows and nobody can find out whether you own that trust or not, because there's nowhere it's recorded. So you're the only one that could disclose who the beneficial interest is, unless you tell somebody else and they tell somebody else. All right, I'll get back to the benefits here in a minute. So should your home be in a trust? Well, I don't know why not. There's no reason for your home not to be in a trust. The trust owns the house, you own the trust. And then again, nobody even knows that you own the trust. In many states, your home can be attacked. Unlike Florida, our home is sacred. Nobody's coming after our home no matter what happens. Well, except the lender, the mortgagee, and perhaps the IRS. But other than that, you have privacy even on your home. So I don't really want to own anything in my own name. So my home's been in a land trust for, almost 40 years now. And it'll always be in a land trust. And any piece of real estate that I buy will be titled to a land trust. What about your homestead exemption? Well, if you live in a homestead exemption state where you actually get a tax reduction because it is your home, you simply put right on the deed that the beneficiary of this trust lives in the home as their primary residence. Put that right under the legal description or have your attorney do it. The beneficial interest of this trust lives in the home as their primary residence. I get homestead exemption and have it the whole time. You put that right on the deed. All right. Will you be able to get a bank loan with no. If your house is in a land trust and you want to go refinance it, they'll make you take it out of the trust, refinance it, and then you can put it right back in the trust. You do not need the bank's permission to put a house in a trust, as I've already discussed. They cannot call the loan due on you. If you are buying the property and you're taking title into a trust, they won't let you do that either. You have to take title in your own name, and then you can put it into a trust the exact same day. In fact, you can have the exact same closing agent have another deed recorded from you to the land trust and have them record that one for you as well. By the way, don't ever put your home into an LLC now. That could cause tax issues. You better have that discussion with your CPA. But there are no tax consequences to a land trust, like zero, nada, zippo. There is a see-through entity from the IRS. It does not change your tax consequences in any way, shape, or form. The trust owns the house. You own the trust. If it's a non-residential property, a rental property, then wherever the money goes through and the payments come out of is the entity that's going to file the tax return, not the land trust. The land trust has no EIN number. It has no federal filing. It has no annual fee, unlike an LLC, which has all of that stuff. So it's a very simple and inexpensive entity to use. And no tax return. The land trust does not file a tax return, nor does it even have a bank account. So don't let anybody tell you to go get an EIN number for your land trust, because if they're telling you that, they are confusing your land trust with another type of trust, usually a business trust that would require an EIN number and a bank account. Whoever's paying taxes, if it weren't in a trust, is the same person that would be paying the taxes if it were in a trust. So I guess I get a lot of questions. Well, what is the annual fee? The annual fee is zero. And then another one is, who is the trustee? And the trustee is going to depend on what state you live in. If you live in a state like Florida and many other states, you can use an LLC or any corporation as the trustee. Of course, that LLC should be your LLC. My LLC is a trustee. I have several LLCs that are trustees for several different properties. I find it very easy to find the trustee when I need them, when they're my own LLC. Okay. So I sign as president or as manager of that entity. Remember, though, the words as trustee always come after that entity. And then you sign as manager or as president of that entity. If it's a C Corp, you are president. If it's a LLC, you are the manager. And that's how you sign stuff. Don't think that because it's your LLC, that it's you. Your LLC is not you. Your LLC is a totally different entity. So it can, and you can direct what that LLC does. And of course, most people do. Now, if you're in a state that requires an individual trustee, like Georgia, Texas, and many others, then you're just going to have to decide what individual that is going to be. And I would suggest you do not use an individual that has your last name. Therefore, your last name is not going to be on public record anywhere. And that's the way, if you listen to me, you're going to live the rest of your life. Keep your name off of public record, period. And that way the world will never know what you own. All right. The beneficiaries now is a subject for a whole different lesson. And that lesson is on the Go Club site. It's called Entity Structuring, I think, something similar. Because if it's your home, you and your wife, you and your spouse will be beneficiaries, most likely. But if it's a business entity, that beneficiaries very well may be an LLC. If you've got rental properties, I'd make the LLC the beneficiary of all of the land trust. And then, of course, you and your spouse could own that LLC. But how you own that is a different subject. I can't get into that today. This is strictly a land trust day. So land trust owns house, LLC owns land trust, you own LLC in some form. All right, now there's four good reasons why, there's many actually, but there's four main reasons why you want to use land trust. Number one is total privacy, as I've discussed. Number two is lien attachment protection. So get this. If a judgment or lien comes against you as an individual, it will attach to any property you own in your name. However, if a judgment or lien comes against you and you own the property in a land trust, that lien cannot attach to a property that you do not own. You do not own that property if it's in a land trust. The trust owns the property, so the lien can attach. That alone, to me, is a reason to use land trust. And that includes an IRS lien. Now, that don't mean they can't come after you and take your interest in your beneficial interest of your trust until you learn how to prevent that as well, which you will learn hanging around long enough. But it does mean that the lien doesn't automatically attach. Thirdly, ease of transfer. If you want to transfer a land trust, all right, let's go back a minute. If I want to sell a house, I have to actually have an attorney fill out a deed, or I fill out a deed, and I got to go downtown and I got to record that deed and I got to pay transfer tax. Okay. Now, that could be a lot of money in some states. In fact, some states it's outrageous. Like I'm thinking Maryland, 3% of the sales price just for transfer tax. All right. So get this. If I own a property in a land trust and I want to sell it to you, all I have to do is go to my Gold Club site and fill out an assignment of beneficial interest form and hand it to you. And when I do, you now own the trust, which already owns the house. So there's nothing changing downtown. There is no transfer tax. There's no recording to do downtown. I'm going to hand you the assignment of beneficial interest. Now, we need to get together and go on some website and pull down a copy of a closing statement that we can fill out, whatever. I don't care what kind of closing statement, but you should have one in your file that are very simple to fill out, because if I transfer that property to you and it's got a loan on it, then you bought it for the loan amount. And so you'll find, if you just look down these things, it's simple to fill out. And really what all I care that you do is make sure that when you report your taxes to your CPA at the end of the year, he or she knows exactly what happened. And frankly, a closing statement is the easiest thing, but I don't care if you take out a piece of notebook paper and say, I signed the beneficial into this trust to Joe Blow, and I owed blank on it. And if he gave you any money or she gave you any money, and then they gave me X number of dollars cash, your attorney can handle it from there. But that is a transfer. It's a legal transfer now. It's a taxable transfer. So if you fill out an assignment of beneficial interest and sell the house, then you sold the house, regardless of the paperwork that you did. So you got to treat it as a sale, and your buyer should treat it as a purchase. But as far as downtown, nothing changes. There are no transfer taxes. So it's very easy to sell a property that's in a trust. And by the way, you didn't sell the property. You didn't own the property. You sold the trust. You sold personal property, which is a trust, which owned real property, which, is an interesting thing to think about when it comes to taxes and transfer taxes and all of that. All right. And also, trusts don't die. People die. When you put a property into a land trust and the beneficial interest dies, nothing changes and there's no probate. Whoever is the other beneficiary, that is assuming there is more than one beneficiary. So if husband and wife own the property, there's no probate. The wife just takes over if the husband dies, or vice versa. If parents and two children die, both parents died, children still own the property, there's no probate. Nobody even knows it happened. There's nothing to record. There's no paperwork to file. There's no probate, period. So just the fact that you own the property in a land trust avoids all that nonsense and avoids all that probate tax. And in the regime we're in now, they're trying to take that away from us. So that might become very, very important. All right. So an LLC, let's talk about LLC versus land trust. An LLC requires an annual fee. In California, that was $800 last time I checked. Most states a whole lot less. It requires a tax return, and it requires an EIN number. And the owners are usually easy to find on public records of the LLCs, most states. A land trust has no annual fee, no fee at all, no tax return, total privacy, and no federal ID number. So already you can see there's a huge difference. Now, here's a debate that I have all the time with people. Let's say you deed a property to an LLC, which I'm assure you that's what your attorneys will tell you to do. Okay. Now, look, by the way, I'm not an attorney. I'm not rendering legal opinion here, and I'm not going to be sending you a bill for it either. Okay. So you definitely need a good closing attorney. But, to be fair and honest with you, I got to tell you that they don't understand land trust. By the way, refer to them as a grantor revocable trust. Don't refer to them as a land trust, and maybe they'll understand better what you're talking about. Grantor revocable trust. So you deed a property into a trust. None of those costs are entailed. But if you deed a property to an LLC, okay, you're going to have some costs, but more importantly, if that LLC is on public record as the owner of the property and you've got 10 houses in that one LLC, now think about what happens. Let's say a big major catastrophe happens in the house and catches on fire and children die in your rental house or whatever, and you get sued and they get a great big judgment against you. Of course, I know that'll never happen to you, but just in case it did. What a judgment against, not going to be against you, it's going to be against the LLC because the LLC owns the house. Okay, might be against you too because you put the tenant buyer in there. Either way, if they get a judgment against the owner of the house, that same owner owns 9 other houses. So everything's gone. Everything's gone because you made a huge mistake of putting all your eggs in one basket. Do not let attorneys talk you into that. One land trust, one house. I don't care how many land trusts you own in one LLC because it cannot be held liable for anything that happens in one of those. The owner of the entity is not liable. The entity is liable. And if you have the LLC on public record as the owner, then it is liable. So no, one egg, one basket. All right. But my attorney says it won't work here. Well, your attorney's wrong because your attorney don't understand these grantor revocable trusts. You think they're some kind of asset protection device, and they're, in a way they are, but they're just the first layer of it. I mean, if they find out you have the beneficial interest, they could come take it if you're not properly protected. But if your attorney says it won't work here, then what you might want to ask, can you show me the statute that says it won't work here? Okay. Now, there are a lot of states that don't have a statute on it. And for some reason, some attorneys think it won't work here because there is no statute. It's not true. Land trusts work in 50 states, regardless of what your attorney tells you. Let me see here. I'm going to catch up. What if somebody convinces you that you've done something evil to put property into a land trust? Well, if you put it into a trust, you can take it right back out of the trust as fast as you put it into the trust, okay? Remember, you recorded the deed to the trust, or your attorney did. So all you got to do now is go fill out another deed and deed it from your trustee back to you, if that's what you want to do. I'd be very careful about doing that, though, because I think you probably better get another opinion, and you probably ought to, whoever advised you to do that, probably needs to spend a little bit of time understanding what these land trusts are all about, because they're so simple. I mean, when you get your head around this thing and you truly understand these land trusts, you're going to say, man, why is that? That wasn't complicated at all. But to be fair, I heard it 7 times. That's right, 7 times before I did anything about it. So I'm no different than you. Okay. But guys, I've used hundreds of land trusts. Believe me, I'm glad I did many times. I give you most of the reasons here. I haven't covered everything I could possibly cover, but I've covered enough to where I can at least get you thinking on using land trust. And by the way, don't confuse a land trust with a living trust. All right, they have nothing to do with each other. A living trust is the trust where you put all your assets into it while you're alive so they can pass to wherever you want to go when you're gone. All right, that's estate planning. Okay, a land trust is an entity that owns a piece of property. They're nothing to do with each other. And in fact, you would put your land trust in a living trust. It would be one of the assets. However, some estate planning attorneys will suggest that you actually deed your property to your living trust. Oh, how incredibly dumb that would be. Never do that. Picture this. I got all my assets in living trust. I've got my whole life's work in the living trust. Everything I own is in the living trust. Now I put that living trust on title on public record as the owner of the house. Some big calamity, some big multi-million-dollar lawsuit comes at me and I lose. What do I lose? Everything in my living trust, which is everything I own, because of that one stupid mistake that an attorney, a non-asset protection attorney, advised you to do. That is a huge no-no. By the way, you won't even get an apology. So they better be very careful to whom you listen. And I am certainly not telling you not to listen to attorneys. You definitely need to listen to attorneys, but I would strongly suggest that you get enough information to where you can intelligently question your attorneys to see why they suggest you do the things that they're doing, and make sure you understand and agree with it, and that they understand the whole situation. They are only human. They hear what they hear, and they'll tell you the answers to questions they thought they heard or questions that you misstated. So if an attorney tells you not to use a land trust, okay, can you explain why to me, please? And can you show me the statute where, it's always, can you show me that statute? And if they can't show you the statute, they're making it up, okay? They're making it up. Or they just, I don't know. I don't know where they get the information from. But anyway, be careful to whom you listen. Question them. Question them and make sure you understand what they're saying for you to do. And then go forthwith based on your feeling about the results of that questioning. That's all I'm asking you to do. Because I can tell you from a lot of years of experience, there's absolutely no reason not to use grantor revocable trust to own houses in your real estate business. Okay, well, that's about all I can get in on this podcast. So, thank you for watching. And by the way, if you want to learn how to do this business so that you actually need land trust to buy houses with, go to, I got a really great webinar, and it explains how we do business in terms business, how we buy and sell houses without using our money or credit, and pretty houses in pretty neighborhoods, not junkers, not crack houses in war zones, but beautiful homes of all shapes and all sizes and all values, and without using our money on our credit. And go to thementorpodcast.com/PC. That stands for podcast. That's the best I could think of. All right. thementorpodcast.com/PC. And there I'll spend about an hour and 15 minutes with you going through what we do, what so many thousands of my students are doing to get the biggest, fastest, and the most money out of real estate and create the most wealth along the way and make multiple streams of income out of one house, not just get one check and have to go out and do it again. In other words, I'll show you how to not only build a residual income that you can live on and beyond, but also grow wealth and get rich while you're flipping houses, not just flipping them and getting a check and paying big taxes and keep on going. I'm going to teach you how to work yourself right out of a job very, very quickly. So again, that's thementorpodcast.com/PC. Thank you for watching.
That's all for this edition of the Mentor Podcast. To connect with Ron and learn how you can attain financial freedom, as well as up-to-date strategies to grow and protect your wealth based on today's discussion, go to www.connectwiththementor.com.